Today we are going to discuss the Federal Judiciary. We will cover the three eras of the court's judicial review, the structure of the Federal Judiciary, and judicial decision-making. In 1801, the Federalists passed the Judiciary Act, which was designed to protect the Constitution against perceived threats from the Democratic Republicans. The law sharply increased the number of district and appeals courts. It conveniently created new judgeships for aspiring Federalists. This was a way to pack the courts with Federalists to protect the Federalists' interest. Thomas Jefferson and the Democratic Republicans vowed to repeal the Judiciary Act of 1801. At this time, nearly everyone agreed that the Supreme Court had the power of judicial review and could strike down state laws that trespassed on federal jurisdiction or violated the Constitution. But it was unclear if they had the authority to veto Congress and the President. Congress did eventually repeal the Federal Judiciary Act of 1801. However, in the Supreme Court case Stewart v. Laird, the court ruled that the Congress had the authority to reorganize the judiciary. In Marbury v. Madison, the Supreme Court established itself as a branch equal among other branches. It established the court's authority to declare acts of Congress unconstitutional. The early era of judicial review can be characterized as the nation versus state era. This era lasted from the founding until the Civil War. It explored the boundaries between the national government and the state governments. In Dred Scott v. Sanford, the Supreme Court ruled that African Americans were not citizens under the Constitution. In addition to ruling that escaped slaves in the North had to be returned to their owners, the majority opinion held that the federal laws outlawing slavery north of the Mason-Dixon line were unconstitutional and infringed on settlers' territorial rights to self-government and private property. This pro-states' rights ruling was very decisive and was ultimately settled through war and not legislation. The second era can be characterized as the era of regulating the national economy. This era stretched from the Civil War to the 1930s. In the case Lochner v. New York, the Supreme Court struck down a New York law restricting the work hours of bakers to a maximum of 10 hours a day or 60 hours per week. The court claimed that they were meddlesome interferences on the rights of individuals. However, this ruling seemed to only apply to men, as the Supreme Court upheld an Oregon law limiting the workday of female workers 3 years later. During Roosevelt's first term, the court consistently ruled against national regulation of the economy. They made rulings unfavorable to his New Deal economic policies. Roosevelt reacted by trying to pack the court, which meant increasing the number of seats on the Supreme Court. He did not succeed in packing the court. However, when 7 of the 9 members of the Supreme Court either died or retired between 1937 and 1941, Roosevelt replaced them with justices committed to the New Deal, and there was a shift in Supreme Court rulings related to regulating the national economy. The third era is the rise of civil rights and civil liberties. This era began in the 1940s. This is when the court began to focus on individual rights. They began to challenge segregation and disenfranchisement. Congress has a lot of control over the structure of the federal judiciary. Only the Supreme Court is mentioned in the Constitution, but the framers knew more courts would be needed. They decided to let Congress create inferior courts as necessary. One example of lower courts are constitutional courts. These are lower level federal courts that interpret the Constitution through judicial review, much like the Supreme Court. Figure 9-2 shows the structure of the state and federal courts. In the federal court system, the Supreme Court sits at the top, followed by the Circuit Court of Appeals and the district courts. Federal courts have to stay within their jurisdiction. Sometimes it is unclear what is in their jurisdiction. They deal with federal questions, those relevant to the Constitution, and cases involving citizens in different states. Citizens can appeal a state court decision to the Supreme Court if they feel that their constitutional rights have been violated. Be sure to check out the video on Miranda v. Arizona, an important case for individual rights in the United States. The Supreme Court delegates to lower level courts, but not directly. District courts are trial level courts in every state. If one party is unhappy with the outcome, they can appeal to the Court of Appeals. The Supreme Court is the final court of appeal. The Supreme Court relies on the lower courts to get decisions right, but does not actually have any command over lower court decisions. There are limits to the internal control of the federal judiciary. The life tenure of judges insulates the judiciary from other branches of government and also insulates judges from each other. Only Congress can remove a judge, but they cannot do so because of decisions that they make. The Supreme Court does have the power to overturn lower court decisions, which encourages lower courts to stick to Supreme Court doctrine. A judge's reputation can be hurt by having decisions overturned. The Supreme Court has the discretion over which cases to hear. Litigants may file a writ of certiorari to request that the court order a lower court to send it records of the trial in question. The rule of 4 is when 4 judges support hearing a case, the certiorari petition is granted. Interest groups, businesses, government agencies, and others submit amicus curiae briefs arguing that a petition should be granted or denied. Judicial doctrine is when the court prescribes guidelines for district and appeals judges to apply when trying similar cases. Procedural doctrine guides the ways that the lower courts should work. For example, stare decisis is the doctrine that calls for following established precedent. Substantive doctrine guides judges on which party in a case should prevail. The Supreme Court decides doctrine in several ways. The court can vote to decide on cases. They issue decisions. When they issue decisions, they come with a majority opinion, a dissenting opinion, and possibly concurring opinions. The majority opinion explains the stance of the majority of the court. A dissenting opinion may be issued when judges disagree with the majority of the court and they wish to explain why. Some justices will issue concurring opinions when they side with the majority but have specific reasons for doing so, which they would like to articulate. So today we discussed the federal judiciary, and next time we're going to cover civil rights.